All right, good afternoon, everybody, and welcome to Tiger Bay today as we enjoy a panel discussion with candidates for the State Attorney's Office. My name is Kevin Cooper. I am the Vice President I'm a Vice President at Mote Marine Laboratory and Aquarium, and I've also had the pleasure of chairing the Sarasota Tiger Bay Club this year. Actually, I think this is probably my last time moderating during this year. And thanks very much, of course, to Jennifer Vine, the Vice Chair and incoming Chair, and Kim Noyes for her and their collective efforts in making sure that we're able to continue to create healthy community debate and panel discussions on topical issues throughout this kind of unprecedented time. So it's great that the efforts they've done to make sure that we can kind of remain connected through Zoom. Just to let everyone know what the format of today's discussion is going to be, I'll do a brief introduction for the panelists. We will move into some opening statements by the candidates, and then we'll move into a time of discussion where we've got some questions kind of pre-loaded up and ready to go. But if you do have any questions, please feel free to submit them in the Q&A box. Please be reminded that questions are limited to Tiger Bay Club members only, and we will try to monitor that area. And if we do have some time towards the end of the discussion, we will throw it over to questions from the audience. And with that, I will move into introductions of our panelists who have been so gracious as to join us today. And I will start with the incumbent, Ed Brodsky. Ed is a career-long prosecutor, having served with the State Attorney's Office for 28 years. After completing rotations in the misdemeanor, juvenile, and felony divisions, Mr. Brodsky served in the Child Sex Crime Unit, prosecuting offenders who preyed on children under 12. He then served as a felony division chief, supervising a felony division, and then as chief assistant overseeing the Manatee County Office of the State Attorney, and then a chief assistant overseeing all 4 offices in the 3 counties that the office serves. Ed became state attorney and was sworn into office in January of 2013 and is currently in his 8th year as the elected state attorney. He is a board certified by the Florida Bar in criminal trial and was appointed by Governor Scott to the State Attorney Advisory Group on Juvenile Justice and Delinquency. He also serves as an adjunct professor at the University of South Florida, Sarasota Manatee, go Bulls, and previously served as an adjunct at the State College of Florida. Ed obtained his undergraduate degree in criminology from the University of South Florida and his law degree from Nova University Law School in Fort Lauderdale. Ed also serves on the Criminal Justice Commission in Sarasota County and on the Public Safety Coordinating Council in Manatee County. He also serves as vice president of the Florida Prosecuting Attorneys Association and has been married to his wife, Kim, for 26 years, and together they have 2 children. Mr. Brodsky, thank you for joining us today.
Thank you.
Joining us also is Betsy Young. In her 2 decades as a prosecutor and criminal defense attorney, Betsy Young has developed a deep, well-rounded understanding of the justice system. She served as assistant state attorney in the 12th Circuit, where she prosecuted thousands of felonies. She has been a defense attorney since 2007. She is the former vice president of the Florida Association of Criminal Defense Attorneys, Sarasota Chapter, and an active member of the Sarasota Manatee County Bar Associations and the Florida Association for Women Lawyers. In addition, she is the chair of the Braden River Elementary SAC and the secretary of the Southeast High School SAC and a member of its IB Parent Alliance. She is also a mentor with Take Stock in Children in Manatee County. Betsy Young, thank you for joining us today.
Thank you so much.
So as I mentioned in the open, what we'll do now is just take some time, a couple of minutes for you to make introductory comments. And for that, we will go ahead and start with Mr. Brodsky.
Hello. Well, I'm honored to serve as your elected state attorney these last 8 years, and I'm proud that over the last 28 years of my career, I've stood with victims. During my administration and during my career with the state attorney's office, I've been fighting to bring justice for the death of Trooper Young, who was killed by Daniel Burns 34 years ago. We've been fighting for Carly Bruscia, who died at the hands of Joseph Smith. We have been persistent in our prosecution, and I was the prosecutor in the Sean Tyson case, which involved the killing of 2 British tourists in Newtown. I was involved in the prosecution of Orlando Valenzuela during my career for a senseless murder of a 9-year-old Stacey Williams in Bradenton. And I prosecuted along the way many DUI manslaughters, horrific child sexual predators, triple homicides, double homicides, and other senseless acts in our community. I'm incredibly proud of the men and women at the State Attorney's Office and their daily commitment to justice. My experience is unmatched. I have 8 years with a record of accomplishments. Crime has gone down over the last 8 years in Sarasota County by 50%. We've done that by being transformative in our approach to criminal justice, by modernizing our office and being responsive to the needs of our community. We've enhanced technology, enhancing our receipt of and delivery of records with law enforcement, the courts, and attorneys. We've addressed head-on the importance of protecting our community. We have formed units in our community of highly skilled, specialized attorneys to address violent and career criminals with a violent crime unit, tackling elder exploitation and neglect and protecting our businesses from economic losses with a white-collar and elder exploitation unit, aggressively prosecuting those that harm and neglect animals, protecting our children from child sexual predators with our sex crimes unit, while recognizing that we needed to do more to further enhance public safety, help people walk away from a life of crime, become productive members of our society, help them become drug-free, crime-free, and addressing mental illness. We expanded our drug courts, our mental health care courts, and we've helped victims of sexual and human trafficking, and our military men and women. I'm proud of the accomplishments over the last 8 years, and I'm honored to be here. Thank you.
Thank you, Mr. Brodsky. And over to you, Betsy.
Thank you. I'm Betsy Young, and I'm running for state attorney. I want to take this opportunity with my opening not to give you a biography of all the things that I've done in the past. You can find that on my website. But what I want to do is talk to you about the future. First, Mr. Brodsky likes to say that everything is fine and dandy in the 12th Circuit. But what I see is that on Tuesday, the manager of a Walmart was shot in the leg during an armed robbery, and a Publix manager was also robbed this week. I don't think that it's fair to tell victims that everything is fine and dandy in the 12th Circuit when there are women in the Meadows community that are living in fear of being sexually assaulted while a predator roams freely on their streets. We can't tell the Newtown community that everything is fine and dandy when there have been over 55 shooting incidents since March, where people have been injured and one person killed. We can't tell that to the people who are on the Flanzer hit list or Sheena Morris's mother. We can't tell that to Darren Kubler's victim. Darren Kubler's victim was viciously beaten while Mr. Kubler attempted to rape her while she was jogging on a trail here in Lakewood Ranch. The state attorney's office filed charges against Mr. Kubler, and 2 months later, after those charges were filed, the state attorney's office dismissed those charges against a violent predator. A reduction in crime is not the end of the conversation, especially when violent crime is up. And I would never sit back and gloat about the crime rate when these violent incidents are still taking place in our community and people are still being victimized. I will never rest, and I will always put public safety first. So that's one of the first things that I want to address, is making sure that we are taking violent crime in our circuit very seriously. The second thing that I want to address is that the state attorney is not only accountable to the public, but also to the assistant state attorneys who serve the office. And one of my priorities will be to address the gender pay disparity among supervisors in the 12th Circuit State Attorney's Office. Currently, there are 2 chief assistants. The female has served in the office since 1991 and makes $36,000 a year less than the male chief assistant, who has 2 years less experience. There are a total of 10 supervisors in the office, 5 of whom are male and 5 of whom are female. None of the women make more than $100,000 a year, and every single one of the men does. One of my priorities as state attorney will be to treat my employees as fairly and as competently as I treat crime victims.
All right, thank you, Ms. Young. And just for those observing us, when you see my finger throw up, we discussed early on about time before we came on here, so that's what I'm doing. And when I think I'll make sure we have a chance to circle back to some of the stuff you mentioned there, Ms. Young, about the 12th Circuit. But what I want to do first is just kind of take a step back and understand we have a continuum of understanding about the state attorney's office, probably viewing this today. So I'll start with you, Ms. Young, and just this is kind of nuts and bolts stuff of, in your opinion, what's the role of the state attorney individually and the office of the state attorney as a whole, and talk about, from your perspective, the qualifications that would elevate you above your opponent as it relates to those things.
Sure. I think number one, on a personal level, the state attorney, the individual state attorney, is the face of the state attorney's office. That is the person that has to make leadership decisions on a daily basis about what policies are enacted going forward, how crimes are prosecuted, how nonviolent crimes are prosecuted, how first appearances, which is the defendant when they get arrested the first time they see a judge, how those things are handled. There's also a lot of internal workings at the state attorney's office, how people are hired, how people are retained, how people are promoted. And those are things that as an assistant state attorney, both in the Second Circuit, which is in Tallahassee, and in Sarasota, I've been witness to two different philosophies of how state attorneys run, how state attorneys' offices run. And also as a defense attorney, I have a unique perspective because I'm on the other side of the aisle, and I see how the decisions of the state attorney's office impact families, impact defendants, and how their decisions can really take a toll on communities if violent criminals are not prosecuted strongly enough, or if nonviolent folks are treated much too harshly. And I think we see a disparity here in the 12th Circuit in the way violent offenders are treated versus the way nonviolent offenders are treated. And that's one of the things that I really want to focus on, is making sure that we prioritize violent cases and that we are taking a more rehabilitative stance on nonviolent cases. So those are some of the priorities and some of the inner workings at the state attorney's office that I think need to change.
And Mr. Brodsky, to you, if I can repeat the question if you'd like.
Sure.
But just generally, how do you view your role as the state attorney individually, and then the office of the state attorney as a whole, and what makes you more qualified to continue holding that office?
Sure, thank you. I think that there's obviously an immeasurable number of roles and responsibilities of the state attorney. I think that ensuring public safety, enacting good, sound policies that protect our community, being responsive to the needs of our community. At any given time, the pressing needs of a community vary from time to time based on the current conditions and the events that are occurring in that community. I think it's being able to analyze the patterns of criminality in that community and being able to respond to it. I think it's also by being modern and being thinking really outside of the box and kind of tackling criminal justice in a new and fresh approach and making a difference. And I think that my record speaks to that. I think that every year over the last 8 years, crime has gone down in our communities. And I think that says something significantly about the work that the state attorney's office does. I think it says a lot about the men and women at my office. And I think that we've shown and we've demonstrated, and the endorsements that I have from the law enforcement community speak to the fact that they're proud of the work that we've done. Contrasting my opponent, 28 years I've stood with victims. My office has stood with victims. We fight for victims, and every day we're trying to impact public safety. My opponent hasn't stood with a victim in over 15 years. In fact, she stands with defendants. She's been standing with defendants for over 15 years. She's been actively defending those that prey on our children sexually. She has no real trial experience. She has no homicide experience. She has no death penalty experience. She has no experience in managing an office like this size, no experience with a multi-million-dollar budget. And she hasn't been with this office in over 15 years. And she has, and based on all of the things that she said thus far, and I certainly hope I get an opportunity to talk about it, I will clearly demonstrate that she has no understanding of a budget and no understanding of our office and how a state attorney's office works across the state of Florida.
Well, and let's stick there, I guess, is a good place to start. In my view in researching this, you have your role as a state attorney, but you also kind of serve as the executive director of that office. You're managing a $17 million budget. You've got multiple offices, I think almost 200 employees in total. So from that perspective, Ed, describe your management philosophies of just running an enterprise like that in terms of how it relates, not necessarily to the prosecution side of things, but to things like budgets and human resources. And maybe touch on some of the things that Ms. Young mentioned in her open.
Well, those are incredibly important issues. I mean, I can address each and every issue. I mean, I can talk about turnover. I can talk about the gender issue if you want me to specifically address those issues. But as you indicated, we are 4 offices spread across 3 counties. We serve over 16 different law enforcement agencies. We receive close to 40,000 criminal complaints a year. And we have various units. And so there are certainly multiple facets of our office and multiple layers of the work that we do. It's about being tough on crime, addressing the criminality in our community, but at the same time, we have to make a difference and we have to be able to help people turn their lives around. So is every decision that we're going to make as we touch 40,000 cases a year, is Miss Young going to agree on every single case? Am I going to stop crime from being committed in our community so that there's no crime? No, that's why we have prosecutors' offices. That's why we have police departments. They're out there working. The men and women in law enforcement are out there doing their level best to protect us, as I am and my prosecutors are. And do I wish that one day we'd wake up and we wouldn't read about a crime being committed in our community? Absolutely. But I can promise you this, that robber that did the shooting at Walmart, we'll be after him and we will prosecute him aggressively.
Same question to you, Ms. Young, in just again talking about, you're kind of the executive director, prosecution elements aside, talk about your management philosophies on budgets, on human resources, and kind of managing the enterprise.
Sure. This is one of the strongest positions in local government. It's the most powerful. It's a person who can take away your constitutional rights and can have you thrown in jail or in prison. And the state attorney's office is the final decision maker in any given criminal case. And the management style of Mr. Brodsky is nowhere more evident than in the Flanzer case. The status quo in that case is to allow people with political connections and people who make political contributions to get off scot-free or with very little punishment, while other people, normal people who commit nonviolent crimes, are harshly punished. When that Flanzer case was going on, when that man was getting a withhold of probation, or withhold of adjudication, so that he can still own firearms when he's off probation, while that case was going on, I was representing a poor Black kid from Northport who committed a dealing in stolen property. That's a nonviolent offense, and the state attorney's office wanted to send that kid to prison for 2 years. And the reason was, quote, he comes from a bad family. Those are the kinds of decisions that are being made by this state attorney, that people who commit nonviolent offenses are being thrown away because of the family that they come from. Do you think that would have happened in the Flanzer case? No, of course not, because that was a person who is wealthy and well-connected. When we talk about the Sheena Morris case and the complete disregard for the victim's family in that case, that Mr. Brodsky for 9 years would not even talk to the mother of Sheena Morris. That is unacceptable in our state attorney. When we talk about the Kubler case, where attempted rape charges were dropped because the state attorney's office did not know how to properly deal with that case, that is offensive. And that is not a management style that our circuit deserves.
Well, this is escalated quickly. Good. So let's just get into some of this meat. Let's just do it. And you kind of mentioned some of this in your intro, Ms. Young, and we'll start with you, and Mr. Brodsky talked about it as well, and it talks about it on his website of, since taking office, crime in the region in Manatee and Sarasota County has dropped by almost 50%, just over 20% in DeSoto County. So maybe from your perspective, and this is where, Ed, you'll have a chance to respond to this one, what does the state attorney's office do that can impact that? And are those numbers, when you put some context around the numbers of 50% decrease in crime in Manatee and Sarasota County with maybe the idea I think Ed was throwing out, you're not going to get rid of all of it. Has the decline in crime we've seen in the region been an effect of the way Mr. Brodsky has run the office? And what would you do that would do things differently to see that decrease further, I guess?
So if your question is, first of all, let me bump up a little and talk about the fact that when I look at the FDLE website, when I look at their statistics, I do not see what Mr. Brodsky sees. I apparently is looking at the world through what rose-colored glasses. And I hope that somebody looks at our crime statistics, because when we're talking about murders and rapes and sex crimes, those things are going up. When you talk about a reduction in crime, if the Sarasota Police Department, if the city of Sarasota is no longer arresting people for possession of marijuana and instead issuing civil citations, our crime rate is going to go down, because there's a whole vast a number of defendants who are no longer going through the criminal justice system. So if you call a murder a suicide, your crime rate goes down. If you drop a rape case, you can say, well, that case was not proven, that was a crime that didn't occur. So I don't believe the statistics that Mr. Brodsky has cited. And of course, the forums that we've been on, we've been in 4 different forums and spoken at several different events. Sometimes it's 54%, sometimes it's 50%, sometimes it's in Manatee that this crime has gone down, sometimes it's in Sarasota. So I would really like Mr. Brodsky to bring out the statistics from the FDLE website that he's looking at, so we can all have a base of knowledge and understanding what he's looking at. The second thing is the state attorney's office has an obligation to protect the public first and foremost. We have an obligation to make sure that violent criminals are punished harshly, that people who commit crimes that affect the elderly and our children are punished. And the fact that Mr. Brodsky is somehow disparages defense attorneys who do a constitutional job. The United States Constitution guarantees people the right to a defense attorney and to a defense. The fact that he would disparage that really concerns me, because he has an obligation to protect people's constitutional rights as much as anybody else in the criminal justice system. So that's very concerning to me that he would disparage my role in the criminal justice system like he does. The other thing I want to point out is I have stood with victims. Since I've been running for state attorney, I have been contacted by so many people who are disappointed in what has happened to them at the hands of Mr. Brodsky. And if you look at people who have contributed to my campaign and who are supporting my campaign, many of them are victims in high-profile cases in the 12th Judicial Circuit, and they know firsthand how victims are treated by Mr. Brodsky.
Thank you. Mr. Brodsky, I can repeat the question. I think you get the gist of it, but I'm happy to repeat it if you'd like.
I think that I've demonstrated a commitment to public safety. I've demonstrated a commitment to working hand in hand with our law enforcement officers, our law enforcement agencies. I've demonstrated a commitment to addressing and tackling various types of criminal activity in our community, and saying, look, we're going to form units of very highly specialized, skilled folks that are going to address those needs. But in addition to that, like I said, we created a violent crime unit to address violent criminals, all forms of violence in our community, and those that are career criminals by the formation of a violent crime unit. We go after child sexual predators and those that prey with a child sex crimes unit. And I understand that defense attorneys have a role and a constitutional obligation to represent those that have broken the law. My point is, you aren't standing with victims. I've been standing with victims for 28 years. You've been fighting for example, one of the defendants that you recently represented, a foster parent accused of sexually molesting very young girls. And you basically argued and insinuated to the jury that these girls are lying, and now you're actively representing a child sexual predator. You're standing with defendants. You're standing with those that prey on our children. And I'm out here fighting every day for our victims, and I'll continue to fight for our victims. And law enforcement recognizes that I fight for our victims, and I fight for our community every day. And I go after violent criminals. I go after child sexual predators. I go after those that exploit and abuse our elderly. I created a unit to go after animal abusers, those that harm and neglect our animals. But I also want to make a difference, because there is a significant number of our folks that need to have mental health issues and drug addiction issues addressed. Those that had that have been victims of sexual human trafficking. And I have a letter that I received just the other day from a victim of human sexual trafficking, thanking us and thanking me for the creation of our Tyler Court program. But I also stepped up to the plate to say, we're going to honor and serve our men and women in our military that have been protecting our community by the creation of a Veterans Court program. So while we have a tough hand and we go after that element that we need to be tough on, and you may disagree with some of the way that we handle our cases, but I can tell you that as a management and as a leadership team, our office very carefully vets these cases. We handle over 40,000 cases. And I'm sure there's a decision that you've read about in the newspaper from a judge about a case that they've handled, or a decision. You're not going to agree, Ms. Young, and the public isn't always going to agree with every decision in the way a court handled something or that we've handled something, but I can tell you that we have carefully vetted the issues. We've considered the evidence. We've considered the facts. We've considered the law. And we've considered what experts have advised us regarding a particular situation. And every day I wake up and I try to make a difference, a meaningful difference about public safety in our community. So that's what my office does, and I'm proud of the men and women in my office. And you can try to disparage my office. Every day I will fight for our victims.
Let's stick there for a second, and I want to try to be cognizant of, again, the continuum of awareness and understanding about some of the things that have been kind of tossed out here in the opening. So when answering, maybe help provide some context. So to your point about you can agree, you can disagree on actions taken, on decisions made, Mr. Brodsky, Ms. Young has brought up the Flanzer case a couple times now. If you could, and I'll give this kind of free, I want to make sure people understand what the Flanzer case is before launching into it. I don't want to misrepresent what it was, but if you could, in your answer, kind of try to give the audience a sense of what the Flanzer case was, and then we'll go back and forth between the two of you about, the perception of how that was handled in terms of Mr. Flanzer.
It's interesting, Flanzer deals with mental health issues. And one of the things that we have created and that we must recognize is that when you look at the folks that are in the Sarasota County Jail, and Sheriff Tom Knight said this himself, that he runs the largest mental health facility in Sarasota County. So here, Ms. Young, who is actively advocating on behalf of defendants, fighting against crime victims in her practice, and advocates that mental health should be considered. And every day, my prosecutors are approached by defense attorneys asking us to consider mental health issues. So it's interesting that in this case, this was an incident in Sarasota County dealing with an individual who was defrauded of several hundreds of thousands of dollars. And Ms. Young wants to talk about this hit list that this guy had in his house. Where he went was not anyone named on this document, which nobody has been able to prove. And there is no evidence that it's a hit list whatsoever. But yet, Ms. Young would call it that. But where he went was not on that document. But the point is that within 2 to 3 weeks after the incident occurred, there was a hearing for him to be released to this mental health treatment facility. And we took a position objecting to it. The state attorney's office objected to it. The defense attorneys advocated for it. The judge made a decision allowing him to be released. I don't hear anyone publicly decrying the judge's decision, and I don't hear Ms. Young decrying the decision. At that time, when he was released, he hadn't received any treatment at that point, right? So at that point, nothing had happened, and it was only shortly after the incident. But he was allowed to go and receive mental health treatment. So why is the defense now, and why is Ms. Young now stigmatizing mental health treatment? The mental health community should be alarmed about her comments and what she has to say. There were not one, not two, there were 3 mental health experts that weighed in on that. Plus, we monitored his behavioral conduct and the things that he did subsequent to this incident. And he has been completely trouble-free since the incident. But yet she also wants to say that it's pay to play or cash register justice. I think if she goes back and looks, and anyone can go back and look, that the attorney that handled that case was a college friend of mine that donated in my original campaign. And that had nothing to do with how this case was handled. And the recommendation and the resolution was not architected by me. That came from the assistant state attorney and the supervisor in that case that recommended that disposition. So certainly misleading completely by Ms. Young.
So, and before I throw it over to Ms. Young, what I want to do for the audience is just provide a little context. Those who are in may recall this. And if I misrepresent this in any way, please let me know. But an individual went to a condo building here in Sarasota, armed, fired shots into a door in a condo complex, and subsequently had a standoff with the Special Weapons and Tactics Unit and was later taken into custody. So I just want to make sure people understand the general nature of what we're talking about when we talk about the Flanzer case. So that being said, and assuming I haven't grossly misrepresented the case itself in as basic a way you possibly can, Ms. Young, I'll throw it over to you in terms of discussing the disposition of that case and perhaps your philosophy on how it should have been done differently.
Yeah. So I think that 2 things. The first is that Mr. Brodsky completely misunderstands the complaint about this case. The complaint about this case isn't necessarily that there was a mental health component. The complaint is that no one else in the history of the 12th Circuit who commits such a crime would get to go to Malibu, California to hang out with the Hollywood elite to get mental health, quote unquote, treatment.
Well, the judge allowed that over there.
I'm sorry, I'm speaking. In court, you don't interrupt people, and neither should you. I know it's been 2.5 years since you've been to court, but in court, you don't interrupt people, and you shouldn't interrupt people during debate. I was very polite listening to you while you were misstating my position, and I would expect that you do the same. He misrepresents my position because there is no one who would get this kind of deal. I have had clients with much less mental health issues, and your office has sent them to jail. Your office has argued to send them to prison. This was a special deal for a special case for a special person who had money and political connections. And you cannot tell me that if there was a man, a black person from Newtown who shot up a condominium in Sarasota County and was sitting in with it, they would be sitting in the county jail. They would not get to go first class to Malibu. The second thing is, when you're defending this man and you're talking about his, he was defrauded, poor fellow, he has mental health issues, poor fellow, it's not a hit list, poor fellow. You sound like a defense attorney, Mr. Brodsky. You're defending this man who committed a violent offense in our community and deserved to be punished. My other complaint about that case is he was not adjudicated guilty. He has a withhold of adjudication. So when he is off probation, he will be able to obtain firearms. He'll be able to vote, unlike so many other people who commit less serious offenses. And that's another one of my big complaints, is that in 4 years, this man will be able to buy a firearm. He is not a convicted felon. When he goes to apply for a job and they say, "Are you a convicted felon?" he can say no, despite the fact that he shot up a condo, had a trafficking amount of drugs, had a history of violence. It's unacceptable, and it's unacceptable to me, and it's unacceptable to the people who are on the hit list that you called a hit list at the beginning that you ignored in the resolution of this case.
Mr. Brodsky, I'll give you a brief moment to rebut what was said there. I didn't catch what you had thrown into the middle. Please unmute yourself, Mr. Brodsky. Or I'll unmute you.
Well, I guess my point was, that she said that I allowed him to be released to go to a treatment facility in Malibu. As I indicated in the very beginning, we objected to that release, and the state took opposition to that, but that was a court decision. Obviously, we respected the court's decision, and it was after 1.5 years of analysis and the time that he spent at the treatment facility and the fact that he did well there, that they wanted to hire him there, and that we received 3 forensic evaluations concerning his conduct and his behavior, that there were those decisions made. So that it was a decision that was very carefully considered. I think that we have an obligation to consider mental health experts, and that's what we relied on, a variety of mental health experts that weighed in on that case. And as I indicated, every decision is not going to be the decision that is going to be wildly popular, but we are doing what we believe is in the best interest of public safety in each and every case that we evaluate as we carefully consider the dispositions of our cases.
Gotcha. Okay. Going back to, again, just giving you, I've got a host of things to ask, but I want to make sure we have some time to cover some of the stuff that was brought up in the open and brought up in and throughout. So, I think, in my perspective, it's important that the state attorney's office be in a position to recruit and retain talented attorneys. I mean, and that can be a challenging issue. And I'll start with you, Mr. Brodsky, because it was kind of lobbied at you, but it's kind of a 2-part question, which is, how do you feel that the office is positioned to recruit and retain, talented, experienced attorneys? And in terms of the gender pay disparity that was brought up by Ms. Young, around some people in your employ, maybe talk about that if you could.
Sure. So the first thing I'll talk about is, turnover. So obviously, I think that folks are very interested in becoming prosecutors. It's a highly rewarding, highly satisfying job, and you quickly learn very important trial skills. but there's an immense level of satisfaction. When I first became a prosecutor, I didn't care what the salary was. I would have done it for free just because of the satisfaction. But turnover in state government is a real issue. You see it, you read about it with, agencies like the Florida Highway Patrol, the Department of Corrections, Department of Children and Family Services, certainly prosecutors' offices and public defenders. State government does not pay certainly what private sector pays, but prosecutors in my office and around the state are highly trained, highly skilled, highly ethical, highly professional, and private sector employment goes after prosecutors very strongly because of who they are and what they bring to their agency. Now, interesting that Ms. Young talks about turnover and that some reflection on me. As she indicated, she went to the state attorney's office under State Attorney Willie Meggs in Tallahassee. She left there. She went to the state attorney's office in Sarasota under State Attorney Earl Moreland. She left there. My record the last 5 years, the state turnover rate over the last 5 years across the state of Florida for prosecutors' offices was 18.77%. We were below the state average at 18.3%. During my administration, Governor Scott and Governor DeSantis have recognized the leaders in my office, knows that we've developed and advanced in my administration, wonderful folks, and during my time, he's advanced 5 people to the bench. Those 5 people that left and were appointed by the governor to the bench count as turnover in my office against me. I've had several assistant state attorneys in my office that have retired after a distinguished career at the state attorney's office. That counts as turnover against me. So if you consider that turnover against me, I plead guilty. But it shows her real lack of understanding about the complexity of the issue here at home and statewide because she's misinformed. Here's an article from 2019, State Attorney R.J. Larizza over in the 7th Circuit, and this was 2019, September, says State Attorney R.J. Larizza has watched as assistant state attorneys saddled by costly law school student loan payments have left in droves to pursue more lucrative jobs in private sector. But Larizza's hopeful that a new law that was going to take effect in October was going to help. In 2018, let me just finish with this. In 2018, 1 in 5 public defenders and prosecutors left their jobs in the state of Florida. 1 in 5, which is 20%. We were below that. This is a crisis across the state. It was a crisis. And then I have an article from the state attorney in Palm Beach County, Dave Ehrenberg, saying that frontline prosecutors and their assistant public defender counterparts are leaving government service at such a high rate that public safety is becoming an issue. The fact that she doesn't realize what's happening around the state and patterns around the state, and that we're completely consistent with what's happening around the state, and actually we're below the statewide average, shows that she's misinformed about public safety issues.
So let's start over to Ms. Young. So I think, maybe address what Mr. Brodsky just stated, but then also, maybe talk about some of the issues and your philosophies on the ability to attract and retain experienced, top quality attorneys at the state attorney's office.
So the total number of departures for the state attorney's office from 2012 to 2019 is 98 people. When you compare that to the public defender's office in the 12th Judicial Circuit, Mr. Eager lost 49 people, so about half of the number of people that Mr. Brodsky lost. And I don't think it's about money. I don't think it's about money for 1 second, because I know a lot of the people that left the state attorney's office, and many of them did not leave for higher paying jobs, and public defenders get paid less than their counterparts at the state attorney's office. It's about job satisfaction. When you have people who are not allowed to make decisions, that are micromanaged, that aren't given autonomy, that are blamed and fired for minuscule, minute things, you will have a high turnover rate. I think the pay disparity as well plays into that, because people know that men are going to be paid more at that office than women are. And that is wholly unfair, and it's not in compliance with Florida statutes. And I'm sure Mr. Brodsky knows that there's a statute specifically about pay disparity, and I'm sure that Mr. Brodsky knows his office is not in compliance with that statute.
Can I respond to that, please?
Sure. Yeah, briefly, please. I'll give you like 30 seconds.
Well, that's not enough time. I mean, you know.
I'll give you a minute. This is what we're talking about. So go ahead. Yeah.
I
So
mean,
let's stick directly to gender pay disparity, Mr. Brodsky.
yeah.
So,
I mean, plain and simple, let's call it what this is. This is gender baiting, and this is tasteless on her part. My record demonstrates a commitment to diversity and gender equality since I was elected in 2013. Her comments demonstrate a complete lack of experience and knowledge of government payrolls and how promotional increases are implemented in a state office. Why? Because she doesn't have any budgetary experience. Salaries are determined by years of service within the office and by their years of service holding various positions. Since taking office, my record for gender advancement has clearly demonstrated that I believe in gender equality. I promoted here in the 12th Circuit the very first female chief assistant in the 12th Circuit history of the office. I promoted the second female chief assistant in the 12th Circuit history.
I think we've maybe running into a problem with Mr. Brodsky. Is that Ms. Young? Are you still with?
Yes, sir.
Okay. Sorry, Mr. Brodsky. You might want to back up just a minute there. We lost you for a moment.
Okay. I'm sorry. Where? I don't know. Okay. So I promoted the very first female chief assistant in the 12th Circuit history. And then after that, when she was promoted to the bench, I promoted the second female to chief assistant in the 12th Circuit history. My chief homicide prosecutors in Manatee and Sarasota are women. My chief fiscal officer for the circuit is a female. I assigned the very first Black female to DeSoto County. Governor Scott has recognized the bold leaders that I have in women and has appointed 3 females to the bench. But let me just point this out. So as I looked at chief assistants, I've had 3 opportunities since I took office to appoint chief assistants during my tenure. 67% have been women. I've had 12 opportunities to promote to division chief, and I've promoted 75% have been women. My child sex crimes position have been 80%. Let me just talk about the pay.
Hold on. Let's. I want to, Mr. Brodsky. Hold on. Let's. You know, I want to move on to a couple more things before we get done. I think I get where you're heading in terms of things, and I appreciate you wanting to.
But I just want to comment about the pay issue that she brought up.
Okay. Yeah.
She talked about the chief assistant. So here's one thing that's a difference. So one of the things that I said that's critically important is that you look at the years of service, right? And while one of them has been with the office, has had one assistant has 13 years in a specialty position, one of those folks has 20 years in a specialty position, over 7 years as a chief assistant overseeing the office, 9 years as a felony division chief, and 4 years in sexual battery. Collectively, then that's 7 more years in a specialized, high level position. And that's why it shows that she has such a fatal misunderstanding of the budget. Fatal.
So throwing it back to Ms. Young, I want to give you a chance to respond to that, and I think we'll move off this topic. But so is it, as Mr. Brodsky said, is this gender baiting, or is this, and is it more bureaucratic than he might have the ability to oversee in his own decision making in terms of where pay scales start and stop and how it works?
Well, if it is gender baiting, it doesn't come from me. Florida statute 27.182 provides each state attorney shall undertake an annual review of compensation policies for the position of assistant state attorney. And within the context of comparable skill, experience, and responsibility, any inequities found to exist on the basis of gender or race shall be eliminated. And what I'm saying is I would challenge the state attorney to show us his written policies, his pay ranges, his pay scales, and how he determines how people are compensated. The fact of the matter is when someone works for your office for 2 years longer and she is doing the same job as a man, and she is paid $36,000 a year less, that's real money. That's not a couple of $1,000s here or there. That is more than many people make in a year. The fact that she is making that much less is terrible. The other thing, when we talk about the 2 female homicide prosecutors, they make about $21,000 less than the men that they replaced. So they're being promoted to those positions and not being compensated as their male counterparts were. And the fact that you would try to bring up that this is gender baiting, when really, in fact, it is a statutory obligation that you have under 27.182, that to me is the offensive part here.
Again, Kevin, I mean, this just shows such a fatal lack of an understanding of the budget and how policy works and the number of years of service and the number of years that an individual, because listen, they're outstanding prosecutors and they deserve more than that they're paid. But you have to look at the years of service in each of those specialized positions that helps determine the salary. And we've conducted that analysis, and I've talked to human resources this year, and they said, absolutely, there are no issues here. So gender baiting, plain and simple, and a deep misunderstanding of our budget is what you're demonstrating today.
Good, healthy piece of it, and we'll move on to a couple other things that have been put out here, but appreciate the conversation to be certain. And then this is kind of interesting, and I think it was brought up a little bit earlier in some of the commentary that was made, and this is kind of a longer question, but so bear with me if you don't mind. I think it was interesting coming kind of from local journalism. So in 2016, the Sarasota Herald Tribune published what would go on to become a multi-award-winning project called Bias on the Bench. In it, the report noted that in Manatee County, judges sentence whites convicted of felony drug possession to an average of 5 months behind bars, and they give blacks with identical charges and records more than a year. This was a report largely focused on the sentencing of judges, but Lee Hayworth, a retired senior judge in Sarasota and former chief of the 12th Circuit, was quoted as saying, "The public thinks judges get to do whatever they want, and that's just not accurate. Judges are just blessing what the prosecutor and defendant have agreed to. These sentences were handed to judges on a silver platter." So I'll start with you, Mr. Brodsky. Is the state attorney's office playing a role in racial disparities across sentences? And how should you as the state attorney be monitoring and correcting the disparities that came up in this report?
Well, okay, I appreciate the question. So as the Sarasota Herald Tribune did that study over the course of 3 years, and they scrutinized and they looked at prosecutors' offices all over the state and questioned conduct around the state. Not once did they ever identify a practice in my circuit during my administration or any of my prosecutors in any of my counties. So I think that says a lot. Now, Judge Hayworth did say that the majority of the cases are recommendations and resolutions that are offered by prosecutors, and that is largely true. But the last article, at the way that the Sarasota Herald Tribune ended their Bias on the Bench series, is by concluding that at the end of the day, the judge is the final arbiter of how the court is conducted and how cases are resolved. So we do play a role. 100% prosecutors play a role, but a judge certainly, I think that there is a lot of truth to that a judge is the final arbiter of those issues and whether to accept a plea or not accept a plea in a courtroom. I think they do a tremendous job. I think that we have demonstrated in our circuit that there is an intolerance to racial insensitivity. I currently, in my office, I believe out of all the law firms in Sarasota County, Manatee County, and DeSoto County, I employ the largest ratio of diversity. I strongly believe in it. I actively recruit to make sure that we have a diverse number of folks in our office. And so it's important to me, and I've demonstrated that we will not tolerate racial insensitivity. And Ms. Young has actually criticizes me for taking action against a prosecutor who did something racially insensitive. I'm sorry, but I'm going to stand up against racial insensitivity and racial bias. My prosecutors have to be free from racial insensitivity and racial bias. And we led the charge. I led the charge as now I currently sit as the vice president of the Florida Prosecuting Attorneys Association. I led the initiative to take on training for prosecutors statewide on racial bias. And every single time that there is a training conducted in our region, we send our prosecutors to the training. It's one of the things that I require and I mandate every new lawyer receive in my office. I will stand up against it. We will not tolerate it, and we do not condone it.
Over to you, Ms. Young. I know that was kind of a lengthy intro question. I can repeat some or all of it if you'd like.
No, that's okay. I think that, you know, when you're comparing apples and oranges, it's where to begin on this particular topic. So there are a lot of things that I take issue with that Mr. Brodsky misstates. So one of the things that, by claiming to have the most racially diverse law firm in the circuit, I think is begging the question, where are people working and what are the jobs that they have? When you talk about whether racial minorities are assistant state attorneys or not, and what percentage of assistant state attorneys are people of color versus how many staff positions are filled by people of color, I think that's a different thing. How many supervisors are people of color? That's also a different thing. I mean, you could say that the McDonald's is the most racially diverse employer in the country, but if all of the people in management positions and all of the people at the corporate level are white and none of them are black, I think that's a problem. The other thing is, if Mr. Brodsky is talking about when he fired a fellow for posting a picture of a squirrel on Facebook, and that's his big claim to fame of being racially sensitive and not tolerating bias, are you saying that that assistant state attorney was racially biased and insensitive? Because I had known him for a number of years and had not found that to be the case at all. In fact, I found quite the opposite, that he was very concerned about making sure that Black folks in the community were treated fairly and dealt with honestly. So I don't know how posting a squirrel picture and firing for somebody for that makes you a champion of social justice. I don't understand that, but I will say that racism should play no part at all in the prosecution of cases. You should be punished for your criminal activity, for what you do, and your criminal history, period. Not for who you know, not for what politics you participate in, not for what campaign contributions you can make, but it should be based solely on the crime that you commit and your criminal history. And those should be the only factors that the state attorney looks at in determining what a sentence is.
So, but as it relates to, you know, the project that the Herald Tribune undertook, I mean, do we have a problem in the 12th Circuit with minority individuals, particularly the youth, being sentenced more frequently or for longer sentences when you're able to, you know, eliminate a lot of the other variables, so they have similar histories, similar crimes, similar scores? Do we have a problem here in the 12th Circuit?
I think that there is a problem, and I don't necessarily know the answer to this because it hasn't been studied here. I don't know why it has a problem in disparities in sentences, but I will tell you that when people come before the criminal justice system and feel that they're not heard and don't feel that they're being treated fairly, that's a problem. When you have an issue in your community that people don't trust you to make a decision in a criminal case solely on the factors of guilt and criminal history, then that's a problem that you have to address. You have to get out in front of that by talking to people in the community, by going to forums, by talking to people in Newtown, by talking to people in Northport, by engaging with other people. And I don't think that our state attorney does that. Mr. Brodsky's very defensive about this issue when really this should be something that we're having an active and open conversation about. This should be transparent. If you want to see what people are getting sentenced to, come on in and take a look at these records. They're all public records. If you want to know our policy on sentencing people for certain crimes, on direct filing juveniles, come in and take a look. But the defensiveness, to me, belies the issue that there's a problem when people in the community feel that there's a problem. So either you're not communicating effectively, you're not leading the office properly, or you actually have a problem that you're ignoring. And those are things that I want to address by, again, actively engaging with the community and having a free discussion about how we can do things better going forward.
So, Mr. Brodsky, you know, directly to that point, I mean, when it said in the report that Blacks in Manatee County with identical felony drug possession charges get more than twice the sentence as their white counterparts, I mean, is that a reality to your knowledge in Manatee County, and is it a problem generally in the 12th Circuit?
Listen, I'm not here to defend anything, and I certainly, you know, to Mr. Young's point, I welcome conversations. I welcome community engagements. I think that it's a conversation that needs to be had, and I think that and that's why I think the trainings that have been happening in our community, the discussions that have been having in our community, I think are important. I mean, one of the committees that I sit on with the Department of Juvenile Justice State Advisory Group is the Disproportionate Minority Contact Committee. And I think that race relations is an important issue, and I think that there need to be discussions had about that. I think that it's important that we are conscious of our responsibilities to remain race neutral, and that race has nothing to do with how cases are disposed of. I believe that our prosecutors and our courts are doing everything to be racially neutral and treating offenders based on the facts, based on the evidence, and based on the law and their criminal history. So is this a journey that we need to continue to work on? Is this a conversation that we need to work on? Absolutely. I think that this is a reality in criminal justice, and that's why I stand for the fact that I'm very committed to doing that, to making a change, to making a difference. And the way that we do that is by having trainings with our prosecutors, is by mandating trainings in our office with our attorneys, is by having conversations. It is by evaluating our, sentencing. I've always been transparent about our sentencing, and I have nothing to hide about our cases and the way that we dispose of cases. Those cases have been analyzed, and certainly the 12th Circuit, wasn't featured in any of the Sarasota Herald Tribune. And I think that doesn't mean we're perfect. I think that we all have work to do, and conversations should always continue to make improvements.
Okay, thank you, Mr. Brodsky. So I'm going to hit one more question here on the list. We can't get to all this stuff in an hour, which is good. It's been meaty, so I appreciate it, but I'll get to one more question here, and then I'll throw it over to you. Both of you will each have an opportunity for kind of a closing remark on this. But, one of the headline issues for some years now in Sarasota County has been the building of a new jail. And a lot of that has had to do with overcrowding in the jail amongst infrastructure and other issues. But overcrowding has been a significant piece of that. And my understanding of it is a lot of individuals in the county jail are just awaiting disposition and they haven't been sentenced. So are there policies that can be supported or implemented by the Office of the State Attorney, like the use of supervised release for nonviolent offenders, to assist and partner with county sheriffs to make sure that we're, lowering the average length of stay or generally lowering the jail population? I'll start with you, Ms. Young.
I think there's a lot to be done to lower the jail population that isn't being done. And the first thing is that we need to look at cases, who belongs in jail and who doesn't. We have a system where people are presumed innocent until proven guilty. So when you have people awaiting trials, they're presumed innocent. So we have a lot of innocent people who are sitting in the jail. They're legally innocent. So one of the things that we need to do really is look at having nonviolent offenders evaluated to be released. And I will tell you that in the age of COVID, the overcrowding not only takes on an issue in terms of just crowding, but it takes on a public health issue as well. And I can tell you from personal experience that I have had cases where I have had clients that are in jail on misdemeanor offenses, not serious offenses, where the state's offer in those cases is probation. And in one case, my client's offer was a diversion program. But the state attorney's office would not agree to a bond, and my client could not afford the bond that he was set at first appearance. So it seems to me that if the state attorneys in those cases have determined that my client is not a danger to the community, that he can be supervised in the community, and then in fact he deserves a diversion program, he should also be entitled to a bond, and the state attorney's office should not be fighting his release. So that's the first thing we need to do, is really look at who is being held in the jail and what the potential outcome of their case is. If it's someone who's violent and you're looking to send them to prison, that's a completely different story. But if you're talking about someone where the offer is going to be probation or diversion, those people should be released. The second thing is at first appearance, that's the first time a defendant goes in front of a judge to get a bond. Mr. Brodsky sends his least experienced prosecutors to that court hearing. And there is a wide disparity if you look at first appearances and what people ask for. I was at first appearance the other day, and on a domestic battery, they asked for $5,000. On a petty theft, they asked for $10,000. We're looking at criminal histories, and the judge can't figure out Why the discrepancy in a non-serious versus a violent crime? Why the disparity? And I think it's because people with little experience don't know what to ask for. When I was a prosecutor in the Second Circuit in Tallahassee, the only person who went to first appearance was the second in command in that office. He went to first appearance every day, Monday through Friday, and he did first appearance because he knew the red flags to look for when people were a danger to the community. He knew the elements of felony offenses, and he knew what to ask for, and it was consistent. And we don't have that here. I think that felony attorneys, people with felony experience, need to go to first appearance so that we are dealing with people who know what they're doing, who know what elements of the felony crimes are, know what they can ask for in terms of release. And that would help alleviate some of that. The second thing that we really need to look at is talking to the sheriff's office and the police department about who actually needs to get arrested. If we're talking about someone with no criminal history who's in their 20s and is smoking a joint, those people can get a notice to appear. If someone is stealing a candy bar from Walmart and they're very young, they can get a notice to appear. These are nonviolent offenses. These people don't have to get arrested and go to jail. And I think we really need to talk about who should get a notice to appear and not be arrested.
So there's a lot in there, Mr. Brodsky, whether it be, supervised release or where we're setting our bonds and whether we're doing notice of appear, civil citation. So I can go into part of the question or all the question, but really about, how does the state attorney's office, again, play a role in what we have in the overcrowding of jails and who is being arrested, who's sitting there waiting disposition? How can your office, from a policy standpoint, help alleviate the needs that are being created by overcrowding?
Well, we've been, for years, I think we've been working very closely with the Sarasota County Sheriff's Office in working with them to help manage jail population. There's been a number of things that recently that we've been doing. One of the things that the Board of County Commissioners recently implemented is kind of trying to resolve and address folks that are being in there on violations of probation. So we now have a violation of probation program to help resolve some of those cases a little bit quicker. We have an early resolution program that we're looking to start here for third-degree felonies. One of the things that I'm looking forward to working with during my next administration as state attorney with the Board of County Commissioners in Sarasota County is what we're currently in the process of working on is the approval that was given for 50 new beds at First Step residential treatment. And we're currently been speaking with Gwen McKenzie, who's in charge over there at First Step, and we've been identifying folks to get them moved over to First Step treatment. In addition to that, the Board of County Commissioners has been considering approval for a 200-bed facility for allowing other correctional options for folks that are incarcerated as another option to incarceration. I have been a proponent. One of the things that we implemented here and certainly have expanded is work offender options. And I certainly talk about that with our attorneys and with law enforcement. And we've expanded that. We've expanded drug court participation so that folks can participate in our drug court program. It was expanded to include an opioid track. We expanded comprehensive treatment court dealing with mental health issues for some minor felons. We were the first in the state to create a pilot program for what we call alternative sanctions so that some of the minor violations of probation could be handled alternatively in-house by the Department of Corrections, and then county probation began doing that. So we have been having those conversations, and law enforcement's been doing a really good job. We have actively been talking to law enforcement agencies about the use of civil citation as means to avoid youth from being arrested. And also we've been talking to them about notice to appear. And we've seen that notice to appears have dramatically gone up. So we work very carefully to manage our jail population. It's a matter of balancing public safety, ensuring that we're safely releasing folks and identifying the right people that are safe to be released back into the community. So it's a very careful balancing act, and we work very careful to do that.
Thank you, Mr. Brodsky. All right, we're going to move into kind of closing statements, give you both 2 minutes before I go ahead and wrap up the program. If participants will stick around just briefly after the end of this, just for a couple brief announcements. But I think Mr. Brodsky started us off at the top. So Ms. Young, I will let you kick us off at the bottom, and I'll give you 2 minutes to go ahead and close us out here from your end.
Well, I'm at home and I locked myself in a room without my dog. So I want to apologize for all the barking. That was my dog, and I did let her in the room now. So she's calm, and hopefully she'll remain quiet.
We're a dog-friendly crowd, don't worry.
Well, I think it looks like Mr. Brodsky's lucky enough to be in his office, so he probably doesn't have dogs running around his feet. So after all is said and done, make no mistake, I will be fighting for the 12th as your state attorney. I'll be always looking toward the future to make our community safer for your children, your parents, your neighbors, for you. I have 2 daughters. One is 16 and just starting to spread her wings, and I worry every time she leaves my home. I've turned that worry into concern for my own daughters into action, and that's why I'm running for state attorney. I have seen on both sides of the aisle, and I've seen in the state attorney's office, how violent criminals are treated in our system. And I don't want to see that happening as my other daughter, my second daughter, the 8-year-old, starts to head out of the house and spread her wings as well. I have a unique perspective on the criminal justice system. As an attorney, I've been on both sides of the aisle, and I've seen the change that needs to take place. And I want to focus on ridding our community of violent criminals and protecting all our kids. Please visit my website, which is betsyyoung.vote, if you need any more information about my background. Don't forget to vote, though, by mail or early or on November 3rd. And I hope to have your vote again as state attorney for the 12th Circuit. Thank you so much.
Thank you, Ms. Young, and same to you, Mr. Brodsky, 2 minutes.
Thank you. So, I'll say that, I've been a prosecutor, career-long prosecutor, 28 years. The last 8 as your elected state attorney. This is a very important position. I think public safety matters to all of us in our community. Experience matters to this position, leadership matters, and vision matters. My experience has been unmatched. I'm board certified by the Florida Bar. I didn't become state attorney overnight. I didn't get to I've managed as a felony division chief. I've prosecuted in child sex crimes. I've handled very violent felony offenders and homicides. I supervise the Manatee County office and then all of our offices. I'm responsible for managing a very large organization, the largest law firm in our circuit. It's a very complex budget with 4 offices, 3 counties, over 160 staff. But we've done a good job. Crime's gone down over 50% over the last 8 years in Sarasota County. We've taken bold initiatives to protect our community, to modernize our office by the creation of the units that we talked about, the violent crime unit, the white collar unit, the elder exploitation unit, the animal unit. But we know more needed to be done, and that's why we wanted to further enhance public safety by dealing with drug addiction and mental health illness with our drug court, our human trafficking court, helping our soldiers with our veterans court, addressing mental health and homeless issues with our homeless care court. What I would say is that I'm proud of the 28 years and the fact that for 28 years I've stood with crime victims. I've partnered with law enforcement, arm in arm, and our police to keep you safe. Contrast that record to my opponent who hasn't done that in over 15 years. I'm proud that during my re-election campaign to be endorsed by Sarasota Sheriff Tom Knight, the last 3 sheriffs of Sarasota County, including our current sheriff, Sheriff Wells, the marshal of the Arcadia Police Department, Matt Anderson, the Police Benevolent Association, the Fraternal Order of Police, the International Union of Police Association, the Sarasota Schools Police Association, the Sarasota Police Officers Association, businesses, organizations like the Gulf Coast Business Exchange, the Manatee Sarasota Building Industry, the Realtors Association of Sarasota Manatee, and many elected officials. I ask that you please stand with me and let's keep our community moving forward. Thank you.
Thank you, Mr. Brodsky, and I want to thank both of you for taking the time with us today. You guys were great. I did like hours worth of research, and I was bothering my friends late into last night. I didn't get to any of it, so next time I do this, I'm just going to wing it and let you all carry the day. There was enough meat on that bone to carry us for a whole other hour. So appreciate you both very much and wish you both the best of luck on the campaign trail. And of course, thanks to our audience today. Our next Tiger Bay panel discussion will be on October 1st. It is going to be the Sarasota County Commission District 5 race. And then we'll be back again on October 8th for the Florida House of Representatives District 72. You're going to see a poll pop up on your screen. Please take just a moment. It wouldn't take more than 30 seconds to go ahead and answer it. And we look forward to seeing you again on October 1st. And thank you again to the candidates joining us today, Ed Brodsky and Betsy Young. Have a great day.
Thank you.
Thank you, Kevin. Thank you, everyone.